Yes, Ms. Fox.
My Lords, thank you. I've been able to take instructions from the parents over the luncheon adjournment about the question of habitual residence and jurisdiction.
Yes.
They did not oppose the jurisdiction of the court in November, and they take the view that they would not continue to oppose the jurisdiction of the court moving forward.
Yes.
They take the view and accept that S would remain habitually resident in this jurisdiction, and it would be the Court of England and Wales who would have the jurisdiction to make welfare decisions about it.
Okay. Yes, but I don't think we need to go further than that. Thank you. Yes.
My Lords, may I then focus on, as you say, the primary question in the case, which is, was there a best interest decision? And if so, was it an adequate best interest decision? My Lords have already gone through the relevant parts within the judgment where Mr. Justice Hayden makes clear that he is approaching the decision which he had to make on the basis that it was a welfare determination and that he was undertaking a best interests analysis in the widest sense. And though that is neatly dealt with by him in two places within the judgment, one is at page 100 of the core bundle.
Paragraph 32.
Paragraph 32 at the end. And then the other place that it can be found is page 104 and paragraph 40.
And also, in paragraph 13, there's the heading. I think that's the heading, isn't it? No, paragraph 13.
22.
Yeah, and done 22. Resolution of his application requires his own views to be factored into a best interest decision relating to his welfare.
Yes.
And 22, as one of says.
And indeed, I've made the point that this decision came not by way of a summary decision whereby Mr. Justice Hayden looked at the decision which the parents had made and considered whether there was prima facie any reason to depart from it. It came after an abundance of welfare-focused evidence, both written and oral, significant submissions from counsel on part of both parties, and the majority of this decision is taken up with an analysis of the facts that apply to S's situation. And whilst it is right that Mr. Justice Hayden doesn't have a section entitled the Welfare Checklist, he, of course, is not required to address each and every factor, and nor is each and every factor of relevance. What we do say he did was to touch upon, in his analysis, a number of the aspects that do exist within the welfare checklist, reminding myself, of course, that this was a decision within wardship, not under the Children Act. But it is clear that the two paramount factors that he looks at are the wishes and feelings of S, because they are set out, and also harm and the risk of harm. And it is hard to argue on the facts of this case that those are not the two predominant checklist factors for the court to give consideration to.
Where does he set out an analysis of the harm, the continuing harm, suffered by S in Ghana?
Well, my lord, I accept that the judgment doesn't have a section identifying the harm in a section that says this is the harm that he is suffering. But if you read the judgment as a whole, I say that it is clear that he was cognizant of the difficulties which S found himself in and which he has expressed through his evidence. And we see that reflected throughout the judgment. Paragraph 32 at page 100 begins, S's desire to return to the UK has not abated. Paragraph 3 has detailed consideration of the impact on S of the manner in which the parents took him to Ghana and left him there.
I think you must mean another paragraph. You said 3.
Sorry, 33.
30. Mine misheard you, I'm sorry. Yes, it does. That's the distinction that Miss Fottrell emerged during Miss Fottrell's submissions between the immediate impact of the concealment, the whatever word you want to use for it, the removal to Ghana, the impact that had on him, and the ongoing harm as evidenced in his statement.
In 33, in the middle, just at the bottom of the typed page, his communications with his father provide clear and almost palpable evidence of his distress.
And it goes on, my lord, that though S has determinedly remained in the shadows, it's important that he realises that I have been acutely conscious of his unhappiness. And I would make the point that actually there was never any dispute that when S said he wanted to come back to the UK, that those were his genuine wishes.
That paragraph is all about his reaction to being removed, isn't it? Because if you read it as a whole, it comes back to their actions were born of desperation.
Yes, and just to test the point, where in the judgment do you say the judge addressed the continuing emotional harm to S of being separated from his siblings?
Well, again, there is no specific reference, I don't believe, to that. But what he does look at is the situation for S in Ghana. That is at paragraph 42, page 105.
Yeah, I'm looking at paragraph 42 right now. And the mention of family in there is his extended family in Ghana.
Yes. And, sorry, my lord.
So what about the harm as a result of being separated from his two siblings in this country?
At paragraph 43, page 105, he reflects upon the regular contact that S has with his father and family, not only by video contact, but by visits too.
I mean, the phrase he uses to describe S's current state of mind about it is he balks at some of its inconveniences in line 3 of 42. And that can't be said to be a full exposition of his feelings, can it?
Well, there is no suggestion in this judgment that Mr. Justice Hayden did not accept as genuine the unhappiness which S was expressing about being required to remain in Ghana and not being able to return to the UK.
But it wasn't just, if you read S's statements, it's not just unhappy. He hates the life there. he hates the experience of being there. He hates the way that he's treated at time to time by other youngsters at the school. He doesn't feel he can go out. He doesn't feel he can go to the church. It's more than just a choice. It's something that he experiences as being very negative.
Yes, I appreciate that was the evidence which S gave
Yes.
in
And
writing.
it may well be that if you're looking at all of that and understand it in the full, a judge would nevertheless also look at the risk of being drawn into gang culture
Indeed.
here and the risk of being killed, and come to the same decision that the judge came to here. But it's difficult to see that he actually balanced up the reality of life in Ghana in detail in the same way that he balanced up the evidence about life here in the UK.
But of course, when he was looking at the risks which flow to S upon having been here in the UK and upon his return to the UK, he was entitled to take into account the fact that the consequences of those risks were of a level of enormous significance. And the height of the case about S in Ghana is that he is emotionally unhappy there. There was no suggestion that he was at risk or in danger in the way that the parents allege he was here,
No,
and the court found he was here in Ghana.
Yeah.
And it is, I say, obvious when he comes to the conclusion that the greater harm to S was in the UK rather than in Ghana, that he was aware and was thinking about the impact on S of being required to remain in a jurisdiction that he didn't want to be.
You said that the magnetic factors were his wishes and harm. That's how you put it. But in fact, for him, the magnetic factor was the harm that he was satisfied with the evidence, the risk of harm in this country. That was the magnetic factor. And your case isn't it, that outweighed the risk of harm in Ghana, and we can assume that even though he doesn't mention it, he had in mind, in addition to the initial harm, the ongoing harm.
Yes,
That would
because
be
he,
no doubt mentioned in the appellant's skeleton arguments below.
because he reflects upon the unhappiness expressed in the evidence by S, but also through the submissions made on his behalf.
But this is why I'm still struggling with this question of alternatives. Because let's assume the judge was entirely right, that there was significant harm to S if he were returned to London and his former milieu. Why does it follow that he would be exposed to the same risk if he were to go to live with the aunt we were discussing this morning in a city in Midlands?
Well, part of the findings which the court made was that S had been drawn into gang culture, criminally exploitative behaviour.
Because of the people he was associating with in London.
Yes, but wherever he is in the UK, the possibility of returning to that was there, and there was discussion about.
Why? Is the supposition that the young people he was associating with in London were also going to be moving to the Midlands?
No, but I think the supposition would be that S may find himself going back to London and being drawn back into those associations, no matter where he was placed. The point, this was indeed the parents' point, was that Ghana provided a safe haven. He was entirely separated physically from the associates who had exposed him to risk. And vitally, we would say, it is clear...
So the supposition is that in Ghana, there's no possibility of meeting anybody who poses a risk to you, really?
Well, there was no evidence that he was. He is at sufficient distance that he cannot simply come back to London and pick up his associations as he had.
So where's the discussion in the judgment about the fact that if he is in the Midlands, then he can return to London and be at risk, whereas if he's in Ghana, he can't?
There's no specific discussion in the judgment, of course. The judgment does reflect the risk to S, that if he were in foster care, that he would be likely to abscond. And that is on that basis that the draw of his associates would likely bring him back.
Yes, can you remind me of that point? Where in the, you're right, that is mentioned. Can you remind me where?
Yes, of course. It's 35, page 101. And the paragraph above reflects the local authorities analysis, which Mr. Justice Hayden shared, that if he were to return to the UK, he could not be placed in London. He could not return to his school.
That suggests that if there was a placement outside London, then the judge thought that was less risky.
Less risky, but still
Yes.
risk, yes. But the reality, my lord, for the judge on the 18th of February was either to cause yet further delay and adjournment on the possibility that there was a family member who had not even been approached to indicate a willingness to be assessed, or to grapple with, should he remain in Ghana with family, or should he return to the United Kingdom and go into a stranger foster placement outside London? Because although it is put that the parents did not want him to return home, S himself was clear from the beginning of the proceedings that he did not want to return to live with his mother. That was never an option before the court.
It's a bit of a side issue, but can you explain to me in the penultimate sentence of paragraph 35, this is after the point about absconding to which you rightly drew attention, but he's commenting on the fact that F had not contemplated the fact that it would probably have to be from London. This would jeopardise F's employment, the family's income, and the happiness of S's teenage sister, with whom S is close. Well, surely her happiness is more jeopardised by him being in Ghana than in the Midlands.
Well, I think that refers to the proposition that the father would leave the family home to live separately with S.
But why did he say with whom S is close? It's not with whom F is close.
I think, without sort of reading into it, one of the issues that was discussed was the fact that S had concerns about his siblings, and equally, if he were to return to the country and the situation for his siblings were to deteriorate.
Oh, I see. So the point is he didn't want his return to jeopardise their situation.
I think that is what it is referring to.
All right, thank you for that explanation.
And he does deal, and in that paragraph, of course, he does deal with the proposition that the father put forward as being unrealistic, that he would separate from the family in order to look after S alone in the UK, if the court's decision was that S should return.
Yes, so in summary, most of paragraph 35 is about the alternative option that you were just referring to, of father seeking independent accommodation for himself and his son, and the judge says, well, that's not realistic for the reasons he gives.
Yes.
By contrast, we don't have the same level of analysis of other options.
Yes, because there were no other realistic options other than foster care. And there is significant analysis of foster care as an option for S.
Okay.
And although my lord has raised the possibility that this judgment is Mr. Justice Hayden looking at S's situation through the prism of parental responsibility, in fact, what we say he is doing is looking at it through the prism of harm. And yes, I accept that the harm which he identifies in the UK features significantly. It is because the nature of that harm is so insidious and so significant. The reality for the judge was either to maintain S in Ghana, where despite his unhappiness, he was within a family placement. There were options for education. There was ongoing contact with his siblings and his father, and now, of course, we know with his mother. Or to return him to the United Kingdom to a resumption of the harmful behaviours that were in existence, and to an entirely unknowable and unknown placement situation. And when one looks at it like that, we say that the best interest decision is self-evidently there and is self-evidently the right one. And my lords, may I also reflect on the fact that...
Can I just ask you about that? What is your comment on the way that the judge characterises your submission to him in paragraph 40? Because he says in the first sentence, there can be little doubt that parents' exercise of parental responsibility was lawful, which is a puddling statement given it wasn't in issue as I understand it. And then he says, Ms. Folks submitted, I should decide whether an interference with such lawful exercise can be justified. Was that the right way of framing the question?
Well, no, he says it wasn't the right way of framing the question, because he's clear that...
Was that the way you put it?
I cannot recall if those are exactly the words I used. But certainly the point I was making was that the parents had exercised their parental responsibility lawfully, and that the court should be slow to interfere with that if there were not good welfare reasons for doing so, which we say there were not. There was not an argument that he should not undertake a best interests analysis. And although a great deal of emphasis is placed on the comment made at the end of the judgment in paragraph 44.
Yes. I was going to ask you about those.
That we say should not be read as the judge saying that in fact there was no role for the court to interfere. That is evident from everything that had gone before, that had he taken the view that in fact S's best interests were not met by remaining in Ghana,
You see, this is why I asked the question about paragraph 40 and the second sentence, because the sentence that we focused on in paragraph 4 seems to be reverting to that way of looking at the question.
Yeah.
it is perhaps unfortunate the way it's phrased, but he's clear that though the parents require no encomium from me, having heard all the evidence, I share their view of where their son's
Yes.
best interests lie.
So
And-
it's a
sorry.
postscript
Yeah.
to the judgment. He's undertaken
Yes,
the major engine room function of the welfare
yes,
analysis, and then he's saying in this paragraph, although I deprecate what the parents did, as it happens, I take the same view they do, having done my own exercise.
and in fact, once you've done that, once the court has reached the conclusion that the exercise of parental responsibility aligns with the child's best interests, then in fact there is no role for
Yeah.
orders.
I mean, initially I read it, I when I first read it, that's how I read it, as just a postscript which didn't reflect his approach. But reading it a bit more carefully in the context of the rest of the judgment, I'm becoming more concerned that in fact it did.
In the previous paragraph, he gives his conclusion on the welfare exercise. Though it's perhaps counterintuitive, I consider he's best placed to receive and absorb this support whilst living in Ghana. So that's his conclusion.
Yes.
And then he goes on to say what he does say in 44 about the parents.
Yes.
So it's ambiguous.
Yes.
Leave it there.
Yeah.
But what is clear from the judgment is that he was not saying there is no role for the court to undertake a best interest
No,
analysis.
and he did. I'm comfortable that he
Yes.
purported to undertake the best interest
Yes.
evaluation. The question is whether he took proper account of this young person's wishes and feelings
Yes.
and the potential for them to experience harm in Ghana alongside the findings about harm that he made in London.
Yes. And of course, he was entitled to consider why the parents had acted in the way they did. And when one is looking at an application made by a young person to essentially override an exercise of parental responsibility, it is inevitable that when one undertakes the welfare analysis, one has to look at why the parents did what they did. And he does that fairly and squarely. He is and sets out clearly that S wants to return to this jurisdiction. He does not want to remain in Ghana, that he is unhappy there. And the fact that he has not gone into huge detail on those issues does not mean that he has not undertaken a proper welfare evaluation. We have set out, of course, in our skeleton argument. I'm sorry. May I
Don't
just-
worry. These machines have advantages, but
They do, but they're a little bit slower.
when you lose your
Um,
bearing, they
in-
have disadvantages.
That there needs to be a balancing of the issues of relevance in the case. That is part of the welfare consideration, and he has taken into account S's wishes and feelings, and he has reached the conclusion that actually, when one looks at the options before the court, the least harmful option is to remain in Ghana. And that is a balance of harm analysis that he was entitled to take on the evidence, and that he did it properly.
Well, what do you say about the discharge of the wardship? That there was the judge with parental responsibility himself for this young person, deciding that the balance was that the young person should stay in Ghana. He, on the evidence about what life was like in Ghana, can't have thought, well, that's all right then. It doesn't solve all the problems that S has, and clearly the decision would have been one that would have landed very badly with S. Was there a responsibility to keep the wardship going, and in a way that would, in many cases, be deprecated, but in this case might be justified, getting the case back in for review in some months ahead to see whether things had settled down or whether, because it leaves S divorced from any ability to engage in the court process once it's over. He's played his card by instructing Mr. Netto. I mean, I'm hedging around this, but just to leave him there and discharge the wardship seems to me to be counterintuitive.
Well, we said that he was right to discharge the wardship. Right. He had made a decision that S's best interests were served by remaining in Ghana. The parents were exercising and continue to exercise parental responsibility for him. There was, in effect, no role for the court because the nub of S's application was not that the court needed to play a guardianship role generally. It was that the court needed to order that he should return to this jurisdiction. On a welfare basis, my lord, one can of course see that the continuation of proceedings that do not provide clarity and closure have the potential for, in fact, increasing dispute, polarizing positions. And one thing the judge was very concerned about throughout the hearing was the ability of the core family to heal some of the rifts and difficulties that had arisen in their relationships. And I say it is not entirely coincidental that the decision having been made, that there has been a shift and there is now contact between S and his mother. And whilst it is tempting, of course, to think that retaining proceedings and wardship in this jurisdiction would have been a positive welfare outcome for him, actually there are quite a lot of factors that would suggest the opposite. And on a practical level, of course, it would have required returning to court for a number of decisions coming up, including schooling, giving again a focus of for dispute between family members.
Yes.
I'm sorry, maybe I'm not following that. Maybe my fault. But are you suggesting that there's no prospect of future disputes over the choice of school?
No,
if he stays in Ghana.
I'm not suggesting that. But of course, if he had remained a ward, then technically the court, no major decisions should really be made for him without the court's permission.
Every time you make a major decision,
there would have had to have then been a return.
Right.
May I touch briefly on the Gillick?
Yes.
Point, if that would be helpful. I know that Miss Fottrell is going to address you on some case law that she has found. I simply would like to make the point that Gillick competence has become a term of art that is often used to describe a young person of an age and understanding to be able to express views. We say that properly, Gillick is quite clear that the principles within it apply to medical decisions. And actually, it's quite hard to see how properly it can apply in any other frame.
And I looked at this a bit over lunch, and it's a different thing from wishes and feelings. It's a necessary facet of the law for medical cases, because the doctors need to know whether they can act on the consent of the Gillick competent child.
Indeed.
And so it is of legal relevance
Yes.
in that setting, and that setting may be relatively wide, much wider than Mrs. Gillick's children, but it's that setting, and I accept my Lord's formulation, and indeed a leading textbook which has my name on it. So you can say that as well.
I was quoting it.
What's happened is the rise of understanding about Gillick competence has infected the approach to analysing wishes and feelings having regard to age and understanding, but it doesn't directly cut and paste as a concept that's directly relevant to the welfare evaluation.
Yes.
I hope I, in a clumsy way, have summarised that.
And Gillick, of course, predated the Children Act.
Yes.
And the Parliament
Yes.
created
And
parental
it may well have
responsibility.
influenced the thinking of
Quite.
Baroness Hale, as she now is, and others in formulating the welfare
Yes.
checklist.
But those are the
Yeah.
principles to be applied, we say, in welfare. And Gillick, which of course was designed to assist clinicians
Yes.
outside the court arena to do
Yes.
their everyday job.
But the fact that in this case we're dealing with this young person who's been assessed by the lawyers acting for him as being able to give instructions, as being described as Gillick competent, is relevant in terms of the weight to be afforded to his wishes and feelings in a
Yes.
way that would be weighted differently were he a 7-year-old.
Indeed. And one could take away the word
Yeah.
Gillick.
Yeah.
He has been assessed to be a competent young person.
Yeah.
And that was never in doubt. And of course, his intelligence was not in doubt. It was a core part of the parents' case that
Yes.
he was an intelligent young man
Mm.
for whom education ought to be an important facet, and that he had great potential.
Mm.
May I just turn my...
Yes. Anything else? Nothing else.
Well, what do you say about the wider human international legal context? I'm thinking in particular UNCRC.
Yes. Well, of course, it's not directly applicable to the law within England.
Except it seems to have, it's not been directly incorporated. You're
No,
absolutely
indeed,
right
sorry.
about that.
It is
But
applicable, yes.
it's come into English law via Article 8.
Yes. When the welfare assessment is done correctly, our law is compatible with the European provisions.
UN position.
Yes.
Yes.
The UNCRC recognises the importance of parental rights and duties. It recognises the importance of a young person, in their terms of growing capacity, being able to express themselves and having weight applied to their wishes and feelings. I say that that is all squarely within how we operate the welfare framework, and both under the Children Act and under the inherent jurisdiction. As regards Article 12 and essentially access to justice, this I would say is an exemplar of how seriously we take that. That there was no requirement for S to obtain the leave of the court because it was an application under wardship. He had the benefit of very experienced legal team, including King's Counsel. He had the benefit of being able to put his views in writing by way of evidence, but also to the social worker through a welfare-based assessment. And the court heard full arguments on his behalf about what is in his best interests and what orders should be made in order to achieve that.
All right, thank you.
Can I just pin you down on the jurisdiction issue?
Yes.
You said that your clients accepted on the German, you take instruction. Your clients accept that this courts of England and Wales should retain jurisdiction.
Yes.
But you don't support the continuation of the wardship.
No, we say it's unnecessary.
So how would jurisdiction be maintained? Should there be a recital to whatever order we make in this case? Because otherwise,
Yes.
it would be jurisdiction would have to be determined by a court next time somebody tried to invoke it,
Yes.
and there would obviously be anxieties about how
But
that might
you ought to
happen.
record your client's position.
Yes.
But if matters remained as they are, and the only thing that changed was the passage of time, then if your client's position is that he won't lose his habitual residence, he does not want to be in Ghana at all. So the idea that he's now become settled and habitually resident in
Yes.
Ghana would be hard to sustain. So it may well be, and given his age, we're talking about a relatively short period of time, that it would not be a live issue, but it would be helpful to be clear about it.
My Lord, fully accept that it ought to be recorded. And in fact, the way habitual residence was put on S's behalf was that the court had to give significant weight to how he himself saw his settled habitual residence, and that is not likely to change.
And to continue until 18?
Yes.
Thank you.
Good. Thank you very much, Miss Folks. Thank you. Yes, Miss Fottrell. Mr. George.
My Lord, may I
Wow.
deal very briefly with a few matters, and very briefly indeed with the last matter that Ms. Fuchs addressed in relation to the UNCRC and the question asked by my Lord Arnold. With respect in relation to the UNCRC, in particular in relation to Article 12, it's not just a procedural due process right. Of course, the complaint in relation to participation in decision making is not just about the court process, which we accept was properly discharged. It's any decision in relation to the child's future. So it's the decision to move the child out of the jurisdiction. And so it isn't just about his participation in the court process. So when one looks at Article 12, one has to look at it in that context. And also the UNCRC includes the obligation under Article 5, which is to recognise the evolving capacities of young people. So a decision made by parents to relocate a child to another jurisdiction and leave them in that jurisdiction away from their family, that is also coming under the UNCRC obligations. And the state's obligation in that regard is to oversee that and to assess and evaluate it. Could I then move on to deal with the return, if I can, to the question of the assessment of risk which was undertaken by Mr. Justice Hayden, and in particular the exchange between my Lord the President and Miss Fuchs about whether or not that evaluation was properly discharged by the judge. And if we understand what is being said by Miss Fuchs, it seems to be suggested that the risk on one side, in other words, in the UK, was so potent and so obvious as a consequence of the finding that the young person had engaged in criminality, that there was no need for Mr. Justice Hayden, as it were, to expand on or examine or explain or even to identify what the risk was on the other side of the weighing scales. And in my submission, that is wrong. It's wrong in this case because there's a downgrading of S's circumstances to a sort of adolescent unhappiness. The bonnet hasn't been lifted by Mr. Justice Hayden. What is said is no risk is comparable. But how can that be a satisfactory position for this court when Mr. Justice Hayden hasn't set out or recognised what the risks to the young person are? It isn't just an unhappiness. We've said in our document, this is a young person who has suffered emotionally and psychologically from the relocation and from the continued presence in Ghana. There is isolation, there is dislocation. There are all the points that we made at an earlier stage. And it isn't enough to simply say on one side of the scales is this risk of this young person having fallen into criminality, and whatever is on the other side of the scales, it doesn't matter because it's not going to be as serious as that. That is precisely the difficulty. We don't know what this young person's future in Ghana is going to be like if he doesn't settle, if he continues to suffer emotional and psychological harm, if he does not integrate, if he doesn't thrive in his education, if he continues to move from one place to the other. And all of those factors were prevalent and present in the evidence. So in my submission, that analysis which is offered on behalf of the respondents is not one that you can accept, and it's not one that this court should sanction, that if the risk on one side is as high as it is said to be, which we would have some difficulties with in any event, although except a finding has been made, then it isn't necessary for the court to unpack the risk on the other side. And I do press the point.
Just thinking of child protection cases
Forgive
where
me.
there's been appalling abuse.
Yes.
The family court doesn't simply say, well, this abuse was really appalling, we'll make an adoption order. The court nevertheless evaluates the factors that are relevant, and it may well be clear to everyone in court that it's likely that the balance will come down one way, but the judge nevertheless has to go through the exercise.
Well, how do we know whether one risk outweighs the other when we haven't unpacked or
And it's about being
examined?
heard. It's about being heard. The person who doesn't succeed, your client, needs to know that the judge has heard what they want to say and taken that into account. And sadly, unfortunately, that doesn't jump out of the judgment.
Indeed.
So it wasn't so much of the parents requiring no enconium from the judge. It was your client requiring an explanation from the judge as to why he was making the welfare decision that he was.
Well, it's that, and it's also the court properly undertaking its welfare best interests analysis. It isn't just about our client seeing that it's been done. It's about it being evident that it's been done. And how can this court be satisfied that it's been done if one accepts the submission that is made by Miss Fuchs, which is this risk is so high that we don't need to look in any depth at if there is a risk on the other side, because that is to work on the assumption that there is no risk on the other side.
And although we're not getting hung up on the elements of the checklist, in fact, his wishes and feelings and his experience of harm in Ghana are two sides of the same coin. What he says about that is what the judge failed to take account of, and those are his wishes and feelings that he wants to be away from there.
And the consequence to him, if those matters are not properly evaluated, that is where the risk will arise in terms of settlement and this suggestion that it's an unhappiness that will pass, because that has to be what follows from the way it is put.
You said it needed a beginning. You said it needed a REG, RBS advantages and disadvantages analysis.
Holistic.
I was Lord muttered the word holistic. You know the reference in the judgments. HW in the Supreme Court has confirmed that that is the approach that should be applied in all cases now when decisions are taken about children.
Well, obviously, my lord is best placed to say that was what VG meant and what it says indeed. And what if
he's allowed to interpret what I said. I'm not allowed to interpret what he said.
Whichever way it travels, the very clear ratio from REG and the subsequent authorities is the assessment has to be holistic, and that's established law. But could I also just deal with the and this is related to this question, the proper reading of paragraphs 41 and 42 of the judgment. And I know that we don't wish to be dancing around in the head of a pin and trying to decide whether a judge was saying this thing or that thing. But if one reads those two paragraphs together,
41 and 42.
41 and 42. Now, Ms. Fuchs has made an attractive submission to the court that this was a postscript in paragraph 42. And
No, the postscript is 44.
44.
forgive me. Yes,
Is that what you meant?
44. Yes, 43 and 42.
You mean 43?
That it is a postscript in paragraph 44. But one has to look properly at what the judge says in, what Mr. Justice Hayden says in paragraph 44. And it is in my submission that evidence that he was, or confirmation that he was looking at it through the prism of parental responsibility. Because what he says is the decision falls within what I regard as the generous ambit of parental decision taking, in which the state has no dominion. And it is that which is problematic. It is the shutting down of the
And it goes back to those cases he quoted.
indeed, and that is the shutting down of the obligation to properly carry out a best interests analysis. That is the real difficulty.
So that is an indicator, quite a firm one, that my Lord's formulation, that he was looking at it through the prism of the parental responsibility
Right.
decision,
Quite.
is made out.
And it's not a postscript, if that is right.
Yeah.
It follows from what is said in paragraph 43. So those points we would make in response to Ms. Fuchs' submissions. In response to the discussion which arose this morning about Gillick competence, we've provided some material to my Lord the President's clerk, Miss Sampson, and if I might just signpost.
Well,
Oh, is this the little bundle we got?
perhaps you're now in a position to answer the question I asked earlier, which is, what's your best case?
Yes,
Because you only need one,
yes,
but if you can't produce one, then you get nowhere.
yes.
And it depends what it is as well.
Yes.
If it's Mr. Justice Baker at first instance, it may not go very far on this court.
The best authority, perhaps, to look at is the decision of Mr. Justice Cobb in the case of Ries. But we have also provided.
What we've been handed is a bundle which has got Miss Folks's skeleton argument.
It was sent electronically to Ms. Sampson, so forgive me. I think it may have been sent just before we came into court. And if
but
perhaps I could just signpost some
All right,
points,
we've
it might be
What's the case
Attractive.
called?
So- the. Forgive me. I think what you have been handed in from the gentleman who arrived earlier was the Association of Lawyers for Children Authorities. So without being unhelpful, I would say put that to one side. That doesn't assist us at the moment.
Well, I don't think.
So,
That's the big one.
The B's, yes, golly. Yes.
so what we have sent to the court, sent to my Lord the President's clerk, but I think it was only sent at about 2 o'clock, so it won't have reached you,
Right, it may be on
is
my
a number of
computer.
authorities and the recent Family Justice Council guidance on children's competency and capacity to instruct solicitors. I don't know whether the best thing is for us to pause so that material can make its way to the court, or whether you want me to just signpost you to the relevant authorities and what we
Well,
say.
I
about them.
think that's probably the better course, and we can catch up.
Yes. We don't propose making lengthy submissions about this, but we're doing our best to answer the question that my Lord Justice Arnold has raised. So the decision of Mr. Justice Cobb, which is probably the most useful decision in terms of addressing this question of the extension of Gillick competence or the use of the umbrella of Gillick competence in other contexts, is a decision from 2017. Forgive me, I've now lost my reference to it. So it's 2017, and it's Ries Parent as Child, an adoption consent decision. My Lord the President and my Lord Justice Baker may recall this decision. And the significance of this decision, which is set out in the head note,
Is it? Could you give the reference?
forgive me,
What's the neutral citation number?
the neutral citation is EWHC 2729 Family.
217.
And it's Family Law Reports 2018 2 FLR 131. But it is a case in which Mr. Justice Cobb considers where a child is also the parent in care proceedings
Oh, yeah.
and consents to Section 20 accommodation and then consents to adoption. And there is a helpful consideration within that judgment, paragraphs 14 to 19, of Gillick applying, as it were, in other contexts, in other words, beyond medical decisions. And it's in my submission, quite a useful and, as far as we can see, the only decision which specifically and directly addresses my Lord's question, which is, does it apply beyond medical decisions? So we would say that is perhaps the most useful decision. And then we would also just refer the court, and this comes from the Family Justice Council guidance on assessing a child's competence to assess or to instruct a solicitor. And again, this has been sent to Miss Sampson.
Yeah, that hasn't come through, I'm afraid.
Paragraph 12 of that guidance refers to a decision of Mr. Justice Williams at first instance from 2019, a case called CS versus SBH. And again, we've sent the court that decision. And there's a very helpful analysis in that decision of Gillick competence applying in cases where courts have to assess children's sufficiency of maturity and understanding in order to decide whether they can instruct a solicitor to participate in proceedings.
That sounds, without having seen the decision, my immediate reaction is that sounds, from the way you describe it, as involving a confusion.
Yeah.
Because capacity, which is what is involved in the question of whether someone can instruct solicitors and so on, is a different question, isn't it?
Yeah, I agree.
It is a different question. I don't want to be appearing to sidestep my Lord's question, but it is addressed in some detail by Mr. Justice Cobb, particularly in his decision as to the maturity and understanding of the young person to consent to the adoption of their own child, which is quite a complicated decision.
It may be helpful if there is potential for confusion for us to look at it and say what we can to hopefully not make matters more confused.
But I don't seek to go beyond. Why would I? But I don't seek to go beyond my Lord's discussion with Miss Fuchs as to the relevance of Gillick in relation to the Children Act. It is used as shorthand for maturity. It is used as shorthand for understanding.
It generally means, does this young person have the confidence to make a specific decision themselves, such as whether to have contraception, or possibly whether to consent to their own child's adoption?
Yes.
It doesn't reflect, does it, the how to approach the question of the young person's wishes and feelings in decisions about themselves, such as who should look after them, where they should go to school, etc. Should they be returned to this country? That is approached by the checklist approach, isn't it? Wishes and feelings
Because it's not their decision.
It is covered.
Judge's decision.
It is covered by the checklist, where possibly Gillick becomes a shorthand for maturity and sufficiency of understanding. Is if one is looking at it in the context of Gillick as a dilution of the absolute authority of the parent, if you like.
Which is your ground too. I mean,
Yes.
and that's why this discussion is relevant,
Yes.
because that's your point, isn't it? You say scope of parental responsibility is narrowed in respect of decisions concerning a Gillick competent child.
Yes.
Yeah.
And therefore, one has to ask, well, why?
That's Hewer and Bryant.
Hewer and Bryant,
Yeah, way back.
which is
Lord Justice Sachs, was it?
Then Master of the Rolls. Lord
Yes.
Tennant.
Danny.
There we are.
and
It's the word, I think.
the ALC actually
parental
deals with this in their document.
the role of parental responsibility diminishes as a child becomes more mature. Which is,
And Gillick is part of that. Article 5 of the UNCRC is part of that. It's also the welfare checklist and the entitlement of a child to have their
Yes,
wishes.
but Gillick makes a sort of cut. It's a cut-off. Gillick.
it's for the doctors.
It's for the doctors have to ask: does this person in front of me have the right to consent to their own treatment? Answer: if Gillick competent, yes. Arguably, according to Mr. Justice Cobb, it seems to me he's right. Does this young person have the capacity to consent to? I notice I use the word capacity. Capacity to consent to the adoption of their child. It's not the same thing as, is it? Does this young person should this young person's wishes and feelings be determinative of their decisions about them?
It's not a... the decision of Mr. Justice Cobb is not a decision in which the court is confronting a young person's views or young person's wishes in conflict with the parental responsibility of their parents. That's not what's at issue. what's at issue in the decision of Mr. Justice Cobb is this person mature enough, and do they have a sufficient understanding to be able to consent to the adoption of their own child? So I accept my lord's point. It's a different factual scenario to Gillick, and there is a difficulty in the sense that the authorities around Gillick are medical authorities. We in the court below referred to a first instance decision of Mr. Justice Mostyn, but his comments in that were obiter comments really, and I don't cite it to my lord as an authority for the proposition that we have raised in ground two. What I think would be unhelpful would be for any narrowing of Gillick by this court, and it may be that it's not necessary for this court to say where Gillick begins and ends, and it may be that you are not attracted to our submissions in relation to ground two, but that doesn't negate the factual position or the legal position, which is that parental responsibility is diluted as children get older and acquire more maturity, and that is not controversial. And if Gillick
Lord Donaldson said that, didn't he, at some
in REW.
Of Lord Donaldson in REW.
But if I've understood correctly, that is an independent principle of the common law which predates Gillick.
It's something which is in common law, and that is confirmed in the Hewer and Bryant decision that the President referred to, which I think is 1970 something. 1970.
It's all part of a long development of children's law in the 20th century, from the time when a child was a chattel of, more or less, of his or her father, not mother, to where we arrived in 1989. It wasn't a sudden overnight change in October the 14th, 1991. It was an evolution. It was part of it.
May I just then, one final issue, just a footnote. There were some discussions between my lords and Ms. Fuchs, and indeed with us earlier, as to retaining the proceedings. In our skeleton argument of paragraph 28, and I'll just get the page number. I think it is page 27, but I'll just check that.
Yep.
We did refer to a relatively recent decision of this court on which the President sat with the Master of the Rolls, which was the decision of O&P, where this court set aside a decision of Mrs. Justice Judd because of the perception that, or the conclusion that she had precipitously brought the proceedings to an end. It had been our position in the court below, once the appeal had been lodged, that we asked Mr. Justice Hayden to continue the wardship for the duration of the appeal, but he declined to do so. There is a real difficulty if this young person has no mechanism or facility to bring matters back. I don't query the jurisdiction point, but I'm not entirely sure that the question of the continuing jurisdiction of this court is in the gift of the parents or can be addressed by agreement between us. I think that is a problematic position legally.
Yeah, about habitual residence.
Indeed,
Yeah.
indeed.
Yeah.
And
I don't think we need to go there at all, other than to record as a matter of evidence what the parents have said through their counsel today.
Yes. May I just check if I've covered everything? Thank you.
We'll rise for a short time because I think it would be helpful if we can at least indicate what our decision is today and let you know what that is, and or if not, tell you that we can't. So please don't go far, if anywhere.
There will be a decision. I mean, when they start talking about Hugh and Brian,
Which is from 1970.
do you think that, I mean, you see this as a significant case in terms of defining PR and children's rights? Or is that just kind of normal discourse thing?
It usually gets such a little discourse that Hugh and Brian Gillick, which was 1980.
Gillick is in I thought it was 86.
It's 6 man.
Yeah. So there's already some important consequences of this case. Oh, okay. Oh, yeah. That's fine. I mean, but it's interesting. Yeah. If they're not sure about it in those terms, because everyone talks about the Children Act 1989 as a kind of, game changer. So this is the way they're trying to place everything in that, in this sort of sweep of change in children, aren't they? Rather than just a case. Well, I mean, it might be important either way, but So what do you think? It's going to be 10 minutes or as long as a piece of string? Quite short. So is this a bit of a cosmetic departure? It won't be long.
They just want to. Unusual.
Probably terribly busy with the plane crash. Yeah. So I was thinking about not ringing the desk, but then maybe I could just email them actually, to be fair. What do you want to email? Should I email Yes. There's no illustration. Yeah, I can do that. This plane crash is all. See that?
Yeah, I was just looking at it now. They say at least 200.
Well, also to kill people on the ground.
Yeah.
I was saying it was what, some kind of doctor's accommodation. Yeah. Also, it's a dream one. And if it's a mechanical book, then. What? Yeah, it's all right.
Yeah, I'm just looking at it now.
Just run the crash itself. Yeah. What just you can't see anything wrong with it. Sorry, my words are going.
They're not there.
They are. They're ready, are they? Do you think you'll get something in the paper?
Well, it's
Or
listed,
is it on oh, good.
so we should see. Luckily, I've written most of it. I just need to.
So are you going to do a? Oh God. So you've written a proper summary of the.
I've done. I've written. Yeah, I've been writing. Typing off as we go.
Yes. No. You must.
I know.
So lucky.
That's what I
Do you know just some weird cases?
She has. They pay out far.
Oh, fantastic. In extremis.
Is court ready?
table.
As will have been apparent during the hearing, we've become progressively more and more concerned as to the exercise that the judge undertook, both as to the fact that he decided to undertake it at the hearing in February, despite having adjourned for more information, but no further information having come, and therefore the options before the court had not progressed in any clarity, but also because of the content of the exercise that he undertook to evaluate this young person's best interests, and the confusion that is evident in the judgment between that exercise and another exercise he undertook, which was to audit the parents' discharge of their parental responsibility. We considered there's a risk that the two became conflated and that the one may have influenced the other. For those reasons, which we will set out in far fuller detail in our judgments, we're agreed that the appeal should be allowed, and so that the parties can engage with the process that must sadly inevitably follow from that. We've announced that decision today. The case will be remitted for rehearing before a judge of the High Court other than Mr. Justice Hayden. I will make inquiries now as to which judge can be free to conduct an early directions hearing, hopefully either next week or the following week, to the convenience, if possible, of the lawyers involved, to set up a rehearing of the issue in the case. And I'll indicate to the lawyers involved this afternoon, if I can, the identity of the judge who's going to take the case on. Because the process is restarting, we take the view that we should reactivate the wardship, but we're, unless persuaded by any view, not minded to make any further directions ourselves, partly because it's really for the new judge to make their own case management decisions, but also because all three of us take the view that the observations that I made at the beginning of this hearing about it not being too late for there to be some form of constructive dialogue between the people who matter, the people who do make the decisions in this family, and I'm including S in that, as to the way out of this current difficulty. And I would repeat what I said about the likely value of mediation, someone with established skills who can come into the discussion and help the parties conduct it in a way that might move towards a resolution of the current impasse. So I don't think I need to say anything further than that. So unless there's any matter that any of you wish to raise, that's the outcome of the appeal.
Nothing further, my lord. We'll have some discussions about an order consequent on your decision.
Thank you very much.
Thank you.
Ms. Folkes?
My lord, nothing from us, no.
No. And repeat my gratitude to the interveners. I'm afraid they haven't had much airtime in the discussion, but their contributions are very much formulating our early thoughts, and we're very grateful to all of you. You're acting pro bono?
My lord, yes, we are.
Well, and you're legally aided?
We are aided.
Yes. Good. Well, however the funding, we're grateful for the help you've all given. Thank you.